powerful courtroom showdown that began with a simple necklace and erupted into a national debate on rights, power, and justice. When attorney Pam Bondi walked into a Colorado courtroom, she had no idea she'd soon be challenging a judge not just legally, but publicly. What unfolded was more than a legal battle. It was a masterclass in standing your ground when the stakes are high. The federal courthouse in Boulder, Colorado stood in quiet contrast to the snow-dusted peaks behind it, sleek, modern, and framed by steel and glass. Inside, the buzz of fluorescent lights and muffled footfalls echoed through its marble halls as attorney Pam Bondi stepped through the security checkpoint. Today's hearing was supposed to be routine, a zoning dispute between a small family-run ranch and a real estate conglomerate eyeing the land for commercial development. For Pam, a seasoned legal advocate for environmental and property rights, this was familiar territory. She walked into courtroom 3B with her usual calm precision, briefcase in one hand, the other brushing a wisp of hair from her face. As she moved to the plaintiff's table, she felt the eyes of Judge Malcolm Rourke, a man known as much for his rigid courtroom rules as for his progressive interpretations of the law, rest on her. Not with the professional detachment she expected, but with pointed scrutiny. His gaze dropped briefly to the silver cross resting just below her collarbone. Without even opening the docket, he cleared his throat and addressed her flatly. "Ms. Bondi, this court maintains visual neutrality. You'll need to remove that necklace." The words hung heavy in the air, drawing a few curious glances from courtroom staff and attendees. Pam paused, the corner of her mouth twitching, not in shock, but in measured calculation. She had faced off against corporate giants and hostile panels, but never a judge questioning her right to wear a personal symbol of faith. "Your Honor," she began evenly, "this cross doesn't disrupt the law, nor the proceedings. It's a part of me." Judge Rourke's expression remained unreadable, but the line had been drawn. What was meant to be a routine legal battle was about to transform into something far more consequential. Judge Rourke's gavel struck once, sharp, deliberate. "This is not a debate, Miss Bondi," he said, voice clipped. "Either remove the necklace, or I will issue a citation for contempt of court and violation of this courtroom's neutrality guidelines." The tension in the room thickened like fog. A few attendees exchanged glances. Even the court clerk, seated rigidly at her station, hesitated mid-typing. Pam remained where she stood, hands folded calmly atop her briefcase. She didn't flinch. "With respect, Your Honor," she replied, her tone unwavering, "there is no legal basis for your request." The courtroom stilled. Behind her, her client, a weathered rancher named Miguel Alvarez, shifted uneasily in his seat, uncertain whether this exchange was part of some prearranged strategy. It wasn't. Judge Rourke leaned forward, his jaw clenched. "This is my courtroom, Ms. Bondi. I set the standard for conduct here." Pam gave a tight nod. "And yet even your authority is bound by the Constitution. I will not be removing this cross." There was a pause. Then, with a slow exhale, Judge Rourke reached for a small pad beside him. "Very well," he muttered. "Miss Bondi is hereby fined $500 for non-compliance with courtroom decorum." The pen scraped audibly across paper. "This hearing will proceed if we can all stay focused on the matter at hand." Pam didn't move. "Before we proceed," she said clearly, "I intend to formally object to the fine and place my argument on the record." The judge's eyes narrowed. "This hearing is about land use rights, not religious displays or your personal grievances." But Pam stood her ground. "And the First Amendment doesn't cease to apply just because we're discussing property lines." The court reporter's fingers hovered over her keys, ready. The bailiff, previously still, shifted uneasily near the bench. Rourke glanced at the clock, then back at Pam. He had underestimated her, and now the courtroom was no longer under his quiet control. The confrontation wasn't over. It had just begun. Judge Rourke sat back, arms folded, clearly irritated. "Proceed, Ms. Bondi. You have 5 minutes." Pam gave a subtle nod and opened her briefcase with deliberate calm. Every move she made was purposeful, not theatrical, but methodical, like a surgeon preparing for a precise incision. She pulled out a single sheet of paper and placed it on the table in front of her, never breaking eye contact with the bench. Your Honor, the fine you've issued is not grounded in law but in personal interpretation. And that's where we have a problem. She lifted the paper, her voice clear and firm. Tinker v. Des Moines, 1969, a Supreme Court case that established students do not shed their constitutional rights at the schoolhouse gate. That principle applies to government institutions, including this courtroom. The ruling specifically protected symbolic expression, like wearing armbands or, in this case, a necklace, with personal meaning. Judge Rourke's mouth tightened, but he said nothing. The court reporter resumed typing, now fully engaged. Pam continued, and then we have West Virginia State Board of Education v. Barnett, 1943, a landmark case that protected individuals from being forced to violate their beliefs. The court ruled that compelling someone to participate in or remove symbols tied to personal belief was a direct violation of the First Amendment. She set the document down. Your Honor, my necklace does not disrupt this courtroom. It doesn't speak, it doesn't interfere, and it certainly doesn't sway legal outcomes. What it does do is represent the freedom this country promises every citizen. The room was silent except for the faint tapping of fingers on keys. Even the bailiff seemed frozen, watching the exchange with guarded fascination. Rourke finally spoke. This courtroom has standards of visual neutrality that, Pam cut in not rudely, but with force, which are not above constitutional protections. That's the point. You've issued a fine, Your Honor, without citing a single case or statute to support it. But I've just cited two that directly challenge your decision. If this fine remains, it sets a precedent, one that says a judge can override fundamental rights based on subjective preferences. The judge didn't respond immediately, his fingers laced together, elbows resting on the bench. It was a posture of control, but his silence betrayed uncertainty. Pam had not come for a confrontation, but now that it had arrived, she was ready. She had flipped the courtroom's dynamic, and everyone could feel it. Pam let the silence linger just long enough to let her words settle, then leaned slightly forward, voice steady. But perhaps what's most troubling, Your Honor, is the selective nature of this enforcement. She turned toward the courtroom gallery, then back to the judge. I've practiced law in multiple states, including federal and appellate courts. Never, not once, has a judge taken issue with my cross. Not until today. Her tone remained composed, but the undercurrent was unmistakable. Challenge met with clarity. So let's talk about neutrality. She gestured around the room. The defense counsel is wearing a wedding band. Your bailiff, respectfully, has a visible tattoo that includes a religious symbol. And I personally recall standing in this very courtroom 6 months ago where a public defender was permitted to wear a pink ribbon in honor of breast cancer awareness. That didn't disrupt proceedings. It wasn't deemed controversial. Judge Rourke's jaw twitched, but he remained silent. Pam pressed on. Or shall we discuss the lapel pins worn by government officials who've stood in this courtroom during hearings? The flag, the causes, the affiliations. They were not hidden. They were not fined. A few murmurs echoed from the seats behind her. Even the court clerk, who had tried to remain impassive, looked up with a flicker of awareness. Pam held her ground. So I ask again, what is it about this cross that justifies a fine? What precedent are we setting when symbolic expression is allowed until someone decides they don't like what it represents? The judge's fingers tapped against the wood of the bench, his lips pressed into a tight line. He looked to the clerk, then to the bailiff, perhaps expecting backup from the institutional weight of his office, but no one moved. Pam didn't gloat. She didn't need to. The moment was working in her favor, and she knew it. If this courtroom's decorum allows for personal expression in some forms, it cannot arbitrarily punish others for theirs. That's not neutrality, Your Honor. That's bias. For the first time since the hearing began, Rourke had no response. The arguments he thought would shut her down had unraveled, and now his authority, once ironclad in this room, had become the very thing on trial. Pam slowly sat back, crossing her arms, the silver cross still resting in plain view. The courtroom had shifted, not just in power, but in purpose, and everyone in it knew something larger than zoning law was unfolding. As Pam exited the courthouse that afternoon, she was met with the sharp chill of the Colorado air, and a cluster of reporters who hadn't even been covering her hearing. Word had spread quickly through the courthouse, and one journalist in particular, Sloan Travers of the National Ledger, caught her eye. A veteran in legal affairs reporting, Sloan wasn't one to chase headlines unless there was real substance. "Miss Bondi," she called out, recorder already in hand, "is it true you were fined for wearing a cross in court?" Pam paused, then met her gaze directly. "It's true, and it won't stand." That was all she said, but it was enough. Within the hour, the National Ledger published a breaking article titled, "Federal Judge Fines Attorney for Wearing Religious Symbol, Backlash Ensues." The story exploded across social media platforms. Legal experts weighed in from every angle, some supporting the need for courtroom neutrality, others calling the judge's actions an unconstitutional overreach. By nightfall, the article had been picked up by national outlets, both left and right-leaning. Hashtags began to trend. Pam Bondi, courtroom faith, judicial overreach. Pam's phone lit up with messages. Some from allies and old law school classmates, others from civil rights groups and media producers wanting her on air. She declined most of them. She wasn't chasing fame. This wasn't a publicity stunt, but she understood momentum when she saw it. More importantly, she understood the stakes. This wasn't about her alone anymore. The minute Judge Rourke made it personal, it became political, legal, and cultural. Inside her apartment that evening, Pam scrolled through a wave of opinion pieces and video segments. A well-known constitutional scholar had posted a viral breakdown of the case, calling it a test of whether personal bias can be disguised as judicial decorum. A former state judge tweeted Bondi did what most attorneys fear. She called out power, in the room and in real time. It wasn't just a trending topic, it was a moment, and though the fine had been temporary, the impact was lasting. Pam sipped her coffee, phone in hand, and knew one thing for certain. This story had already grown far beyond the courtroom's four walls, and the real fallout hadn't even begun. The next morning, just as the sky over Boulder began to lighten with streaks of soft gold, Pam stepped into her office to find her assistant Avery Chen already waiting, tablet in hand, expression tight. "You need to see this," she said quietly. Pam took the device, eyes scanning the freshly released document on the screen. It was an official filing from Judge Rourke himself, a formal complaint submitted to the Colorado Bar Association. The language was sterile, but the intent was unmistakable. Attorney Pamela Bondi conducted herself in a manner that disrupted courtroom proceedings, undermined judicial authority, and demonstrated behavior unbecoming of an officer of the court. Pam let out a dry laugh, one without humor. "Unbecoming," she muttered. "That's rich." Avery folded her arms. "He's retaliating, plain and simple." Pam knew this tactic all too well. Turn the challenger into the accused. Shift the narrative from why authority was questioned to how it was questioned. It was a classic maneuver, an attempt to bury the real issue beneath process, paperwork, and institutional loyalty. "He's trying to make an example out of me," Pam said, pacing slowly. "He lost control in his own courtroom, and now he wants the last word. Through bureaucracy." The complaint wasn't just a shot across the bow. It was an opening salvo in what Judge Rourke clearly hoped would become a quiet, private disciplinary proceeding, handled behind closed doors where reputations could be bruised without headlines. Pam turned to Avery. "What's the timeline for response?" Avery replied, 10 days. If the bar deems it substantial, it could move to a formal inquiry. Review panel includes senior attorneys and a few judges." Pam gave a slight smile, not out of relief but because now she could see the full board. "If Rourke thinks I'm going to handle this behind the scenes, he's miscalculated." She wasn't just defending herself now. She was defending the precedent her resistance had already begun to set. She wouldn't allow the judge to reframe the narrative into one about a rogue attorney disrupting decorum. Rourke had tried to fine her into silence, and when that failed, he went for something more insidious, institutional pressure. But Pam had faced worse, and this time she had the public watching. "Draft a statement," she told Avery. "We're not playing this in the shadows." And just like that, Pam shifted from courtroom defense to strategic offense. She wasn't backing down, she was just getting started. Pam didn't waste a second. With Judge Rourke trying to maneuver behind closed doors, she knew the only way to stop this from becoming a quiet smear campaign was to bring it into the light. She reached for her phone, scrolled past missed calls and news notifications, and found the name she needed: Sloan Travers. The journalist answered on the second ring, voice sharp and alert. "Pam, I was just about to call you." Without preamble, Pam replied, "Rourke filed a formal complaint against me. Claims I disrupted proceedings, challenged judicial authority, and acted unprofessionally." Sloan paused for a beat. "So he's retaliating because you exposed him in public?" Pam exhaled. "Exactly. And if I let this stay buried, he wins the war he lost in that courtroom." Sloan didn't hesitate. "I'll run it. Full breakdown, quotes, legal expert reactions, the timeline. He's not going to own this narrative." By nightfall, the National Ledger had published its second explosive feature: Retaliation on the Bench. Judge under fire after filing complaint against attorney who challenged his ruling. The piece laid everything out: the fine, Pam's constitutional defense, the public reversal, and now, the internal complaint. Sloan had included commentary from prominent First Amendment lawyers and a retired judge who described Rourke's move as a thinly veiled attempt to reassert control through institutional intimidation. Pam's inbox flooded with support from fellow attorneys, law professors, and even students who had watched the courtroom clip go viral. In one stroke, Pam had flipped the narrative. Rourke's attempt to silence her through formal channels had become a national case study in judicial overreach. And this time the media wasn't speculating, they were dissecting his every move with a microscope. Pam didn't need to speak much, her actions were doing the talking, but she understood momentum, and she wasn't going to let it fizzle. "This isn't just about me anymore," she told Avery. "It's about making sure this doesn't happen to the next attorney or the next person who wears something someone in power doesn't like." And with that, she began planning her next step. Not just defense, but reform. 2 days later, the pressure reached a tipping point. The Colorado Judicial Ethics Review Board released an official statement announcing it would be launching a preliminary inquiry into Judge Rourke's conduct during the Bondi hearing. The announcement was brief, almost sterile in its wording, but it was a seismic shift. What had started as a fine over a necklace had now escalated into a judicial ethics investigation, one with potential consequences far beyond Rourke's courtroom. News outlets pounced on the development, and legal commentators across the spectrum weighed in. "We're now asking a fundamental question," one constitutional law professor said on national television. "Can a judge use personal interpretation of decorum to silence lawful expression? And if so, what recourse do citizens have when those lines are crossed?" Judge Rourke, realizing the momentum was no longer on his side, issued a carefully worded public statement. Standing before cameras on the courthouse steps, he spoke for less than 2 minutes. "I have always upheld the dignity and neutrality of this courtroom. The actions taken were in the interest of maintaining judicial order. However, I respect the review process and will cooperate fully." His tone was measured, but his expression betrayed strain. It was the look of someone accustomed to control, now scrambling to preserve what remained of his authority. Pam watched the clip from her office with quiet resolve. Rourke was still clinging to the word neutrality, still framing the issue as a matter of decorum rather than rights. But the narrative had already shifted. His decisions were no longer insulated behind courtroom walls. They were public, dissected, and challenged. And now, with the system watching him as closely as it once watched her, the balance of power had begun to shift permanently. Pam knew this moment called for more than a viral headline. It needed clarity, conviction, and closure. That afternoon, she sat at her desk, sleeves rolled up, crafting a public statement that would bypass spin and speak directly to the heart of the matter. When it was published across her legal network and shared by civil rights organizations, it read less like a defense and more like a manifesto. "This is not about jewelry," the statement began. "It's about the quiet ways power tries to shape who belongs in the room. I stood my ground, not to make a spectacle, but because I believe no judge, no institution, no seat of authority has the right to strip away personal expression protected by the Constitution." Pam's message resonated. She wasn't defiant for attention. She was measured, focused, and principled. If a respected member of the bar can be penalized this easily, she wrote, what happens to the young attorney without a platform, or the pro se defendant who doesn't know they can say no? Her final line was both a warning and a rallying cry. This was never about me, it was about all of us. The response was overwhelming. Law students reposted it with admiration. Advocacy groups used it in campaigns. Even a former federal judge shared it with a single word: courage. Pam hadn't just defended her rights, she had reframed the entire conflict into a national conversation, and in doing so, she left Judge Rourke not just facing scrutiny, but history. Weeks later, the Colorado Judicial Ethics Review Board concluded its inquiry. While Judge Rourke avoided formal disciplinary action, the findings were clear. His decision to fine Pam Bondi lacked legal precedent and raised serious concerns about selective enforcement and judicial overreach. Though the board stopped short of a public reprimand, the damage had already been done. His reputation, once untouchable, was now shadowed by scrutiny. Within legal circles, he was no longer just the hardliner on courtroom decorum, but the judge who tried to silence a cross and lost. Pam, on the other hand, had emerged stronger, not as a martyr, but as a catalyst. Her client Miguel Alvarez won the land use case, a quiet but satisfying victory. Yet for Pam, it was almost secondary. What mattered more was the precedent she'd helped shape, a public reminder that authority must always answer to principle. The courtroom was no longer just a place where arguments were made, it was now a symbol of something greater. And as Pam walked down those marble courthouse steps for the last time that winter, the silver cross still rested proudly on her collarbone. She hadn't just worn it, she had defended it, and everything it represented. The story of Pam Bondi's stand in the Boulder courtroom delivers a powerful lesson about the importance of courage in the face of authority, and the necessity of defending fundamental rights, even when it's inconvenient or risky. It reminds us that principles like freedom of expression and religious liberty are not theoretical ideals. They are protections meant to be exercised, especially when challenged. Pam didn't escalate a courtroom drama for attention. She responded to an unjust act with clarity, knowledge, and conviction. In doing so, she exposed how easily power can be misused when left unchecked, even by those sworn to uphold justice. More importantly, the story reveals how one voice, when firm and informed, can shift the balance of an entire system. Pam's refusal to quietly remove her cross wasn't just a personal stand. It became a national conversation about judicial overreach and the silent pressures professionals often face. The lesson is clear: silence may be safe, but it rarely changes anything. Real progress comes when someone dares to speak, respectfully, intelligently, and relentlessly. Pam's story teaches us that we don't always need a podium to make an impact. Sometimes, all it takes is one person saying, "This isn't right," and refusing to back down.